of IP became protection of IP became the core of WTO organization, World Trade Organization establishment, which came into effect from the 1st January 1995. Uh, so, even the TRIPS agreement mentions in the Article 9, paragraph 1, especially mentioning about the subject matter of the copyright, how copyright is protected under the TRIPS. It says that Article 1 to 21 of the Berne Convention, along with the Berne Appendix, which gives the facility of compulsory licenses issuing by the developing countries and the least developed countries for the purposes of reproduction and translation. So these compulsory licenses can be issued for publishing the books. Books are when not available or affordable, uh, and a certain period of 3 years rule is there, translation and all that. Not only the reproduction. Then what happens? This was included there. So the widening of the idea which came forward there. But before 1995 and the 1886 to 1990, a lot of technology development happened. Now we are seeing live, we are living with our AI. At the time came the from terrestrial broadcasting, this satellite broadcasting came. So when the broadcasting started, not only the television broadcasting, before that radio broadcasting started. When radio broadcasting started, it gave a platform to content creators and also performers. So performers who used to sing in a stadium or in an auditorium started walking to the radio stations and started singing there. So their right need to be protected, which Berne Convention did not protect. The Berne Convention protected the rights of only authors of literary and artistic work, not performers. So a new right, the related right it is called. Why it is called related or neighboring right? Because performers creating a new right by singing or performing already existing literary work, a song written by an author, like Guljar writes a song, and the A.R. Rahman gives a music. So Guljar's lyric is a literary work protected by the copyright. A.R. Rahman music is a musical work protected by copyright. So two works are the core uh, for a new right called performer right, where Sonu Nigam and Shreya Ghoshal, Arijit Singh or Sunidhi Chauhan singing a song, performing. So a performing right is created, which is related to already existing copyright and literary rights and the musical right. And then this first performance happens. It may happen on the stage, or mostly it happens in the studio where recording is done. The music company's recording company creates a master copy, and that master copy is uh, creating a new related rights called sound recording rights. So there is another right is created. So there is a sound recording right, there is a performer right, and also the broadcasting right, which the performer or author gives to the broadcasting organist to perform. So new technologies came. So international copyright system recognized this new rights and started protecting that. So never new technology killed the copyright system, whereas copyright system expanded. That's what I mentioned in my Twitter reply to Elon Musk. Then what happened when 1994? When 1994, the Marrakesh Agreement was finalizing the establishment of World Trade Organization. It came with a bouquet of agreements. There was a general agreement on trade and tariff called GATT that was established, and that is for the goods, trading of goods. For services, TRIPS came, sorry, the trade in services came, and then intellectual properties, the TRIPS came. So when you know how much time it took more than 40 years nearly to establish this World Trade Organization. What was the reason? After the World Wars II, United Nations was created by the countries to so that the it will successfully stop the future wars. Of course, it was United Nations is successful in stopping the next world war, but small wars, the bilateral wars are goes on now. Still, two more wars are going between Russia and Ukraine, and between the Palestine, Hamas, and Israel. So UN is not successful in stopping, but they could successfully stop the world wars. And it wanted a development of countries devastated by the World War II, and also develop the countries like India and other countries who got freedom very after colonialism ended. So in 1950, there was a conference called Bretton Woods under the aegis of United Nations. They decided to set up three bodies for the development and progress of all the developing countries and least developed. First organization was set up under the Bretton Woods Conference, that is setting up of International Monetary Fund, which supported these countries' economic revival of their macro economy and micro economy. So then came World Bank was set up to sector-wise development of these countries, whether it's in education, irrigation, power, or social development. So various other projects were started getting funded by the World Bank. The third body was to be set up by the World Trade Organization. That could happen because a lot of differences between the developed world and developing world. Various rounds of negotiations started, but only in 80s the Uruguayan round started. But even the Uruguayan round finalization took 24 years, which was finalized in 1994 in Marrakesh Agreement to finally set up the WTO, World Trade Organization. At that time, countries like Japan, Germany, and Switzerland, various other countries, introduced a new element when TRIPS was being finalized. So, internet issues. Then WTO said, no, we can't delay the further introducing the new issues in that, because in internet at the time creating havoc with the online piracy. How to contain online piracy in early 19 itself. And then India and other countries were grappling with the digital divide at that time. Despite India had already got the comparative advantage in ICT technology, but the Bangalore-based ICT at the time was doing a kind of backhand help to the famous Silicon Valley giants, like whether it is Microsoft, IBM, other countries, sorry, other big giants in ICT, big giants. So these countries said that don't delay the WTO agreement. Let us give the task of protecting the copyright on the internet and digital networks to the another UN body called World Intellectual Property Organization, which is well equipped, where all WTO members are members. They can sit together and do the norm setting. So, what was the need to protect content in internet? Because the internet, removed the uh, hurdles in the trade because electronic commerce websites came the Amazon or Flipkart, what you know, these electronic commerce websites started behaving like a marketplaces where you walk in physical market, buy goods. So everything was made available that included the content, whether it is the books or software or music or films, everything available. So it is a win-win situation for the film industry or a broadcasting industry or publishing industry, including authors, sell their content wherever they are sitting. So you can buy books from the Western world sitting in your place. So anywhere, any place, you can download the content by online purchase. But this facility was spoiled by the unscrupulous elements who unauthorizedly get the pirated versions, the illegal copying of these original works and uploading over internet. So there was a market failure because of that. When something is freely available in the market, why do you go and buy it? You go to Pirates Bay website, watch your favorite film or watch your favorite web series. You don't log on to the content or go walk into the theater to watch a film or go to the bookshop, buy a book when book is already available, scan, copy or photocopy book. Somebody is sending you through the email, peer to peer. Copying is happening and supply is happening, distribution is happening. So this was needed to be contained. Luckily, what happened? The intelligent brains come out with a technological solution called encrypted devices to stop the online piracy. So these encrypted devices were introduced by the right owners and authors and performers as voluntary measures. So there are two kinds of DRM, the digital rights management started. One kind of device meant for access control. So you don't get to access to the content unless and until you register your name, sign up. So provide your information, name, telephone number, email ID, and create a login and a password and pay a subscription fee. That's what you must have done during the COVID lockdown times. When COVID lockdown came and all the multiplex theaters were closed, you can't walk in to watch a theater, a film, and the television content was very boring. Everyone is not interested in watching Sasbo serials. You need something different, and that gap was filled up by the Amazon Prime, Netflix, and other OTT platform. There, this content is not freely available, unlike a radio FM. Radio FM makes you the content, the songs available to you. You need not subscribe. Simply switch on. You will listen. The how the the platform owner makes money through the advertisement revenues. Their advertisement revenue is the business model. Here means subscription based business model. So on mobile, you want to watch 199 rupees. You want to watch on your television screen is 499 rupees, something like that. You all subscribe, and you got entertainment, those harrowing conditions of COVID lockdown. Man, it's a win-win situation. It's an affordable amount. You got the latest films, web series, everything you watch, and it is a money-making mechanism, marketing model for these online platforms. So copyright is respected here. No hacking happened, but online when it was introduced, hacking was happening and piracy was happening. Various pirated websites came. To stop that, these devices came. So access control. Then another one is a copy control. Even though you access, you can't copy it. But what happened? There are intelligent people, I can say perverted intelligence. They use their intelligence instead of subscribing, creating password and log in to de-encrypt that by making amount of payment through subscription. So these people illegally started uploading. And when it is freely available, people started watching that and downloading that and sending through email, peer to peer distribution. And there was a market failure. To stop that, because it was happening at international level, there was a treaty to set minimum standard required. So member state decided to move that issue to WIPO, and we had WIPO copyright treaty in 1996, which extended the rights given to authors and authors of literary and artistic works in 1980s. Sorry, 1886. They extended those rights in 1996. So after 110 years, the new technology came, new kind of protection started. For performers, for oral performances, WIPO performances and phonogram treaty came. Then audiovisual performances in 2012, the Beijing Treaty for audiovisual performances. So the new treaties, adjustment of copyright, uh, and related rights, it never dead. So do you think that artificial intelligence is going to kill it? No, it will never happen. Because, so what is copyright? Copyright is an expression which is to be original. So I already told you, when convention said it is automatic, the moment you write or create the content, copyright subsists in that, it's protected. You do not go and registered copyright, unlike patent where you have to register, then only you will get. Otherwise, uh, that patent, your right over that new technology with the novelty, inventive step, the industrial application, these tests is has to pass. So unlike copyright, it has to be registered, then only it has to be released to the public. But in copyright, nothing is going to happen if you don't register. So it is automatic. And so what happens? I give you an example. Kapil Chopra, a script writer, he wrote a film script called Zero. He came to know that the Mukesh Bhatt and Mahesh Bhatt were was looking for a script for a Jism 2 film. So they approached this guy. Through email, he sent his uh, a script copy to them. There was a offer, consideration, acceptance, everything was there through email. But when film was finally released, the Vishesh film owned by the Bhatt brothers did not give credit for the Kapil Chopra. He went to the court. Court said, no, it is a violation of copyright of the Kapil Chopra. It is illegally misappropriated, adopted into a film. And a compensation of 20 lakhs has to be given to him. And when the film is released over the broadcasting networks, his credits has to be given. When a DVD is released, his credits, the name of the screenplay writer has to be written. So courts come out and protect the copyright of the authors, even though it is not registered. Kapil Chopra never came and registered his copyright in Copyright Office. Then you say that why do you have a Copyright Office? Not only India, more than 50 countries. It is there because it gives a kind of voluntary registration method. It gives you a certificate as a prima facie evidence. Anything is illegally and without approval or without consent, without compensation, your content is used. So that's what Section 51 of the Copyright Act says. What is infringement means if without a license, your content is sold in the market, reproduction is made and distributed without your consent, and shown in the a communication to the public happens, a performance happens, a translation happens. No one can translate the article written by you, book written by you, without your permission. So the moment you give a permission to the article or a book written by you in English language, translation of that work into Bengali, Assami, Hindi, or Gujarati, the translator will get the similar rights, the bouquet of economic rights, right to reproduction, publication, communication to the public, public performance, translation, adaptation, and all that. But these rights are limited to that language work only in which he is translated, not in the original work which author has given. So he will pay some royalty to the original author to do the translation and publish that translation and distribute and sell uh, and do whatever activity he has to do as per the law is given right to him as an author of a translated work. So that is the beauty of the copyright. So what happens uh, to the work created collectively? For instance, you take an encyclopedia or a newspaper or the where various authors write articles or chapters, which is included there. So it is a collective work. Collective work, even a book edited. Let us say Professor Kalpesh writes a book on intellectual property law. In that, he writes an introduction, and various chapters are there. Couple of chapters on patent, design, trademark, geographical indications, and the semiconductor and industrial design layout, plant varieties, and Farmers' Right Act, and the new trade secret law is coming on that, and copyright and related. So these various chapters are written by various authors. So when they write chapters, they transfer the right, agree to transfer the right to Dr. Kalpesh, who in turn negotiates with the publisher and get that book published. It's an edited book on intellectual property rights, published by some XYZ author. So that is the way the copyright works. Unless and until the chapter writers don't transfer, so and book can not come out. So what happens in articles written? So when you written various newspaper articles, you professors in the law keep writing. So what happens? That right is taken over by when it is published in that newspaper or magazine by the employer, that is the owner of that magazine, owner of the newspaper. But when the newspaper articles you have written, let us say on a criminal law, various times, and the three new criminal laws which have been introduced recently on that. So you can cull out all the articles written on a single topic. You can bring out a book unless and until through a contract you not completely transfer the work. So you are given the only right of publication of that article only in Hindustan Times, only in Indian Express, the article you have written by you. That extent is okay. You don't have copyright on the published work in that newspaper. But separately, the same article, your collection of such articles in which various newspapers you have written, you can publish that as a work, your own work. That is the beauty of the collective work. Then, work of joint authorship. So, you must be writing an article in a collaboration with one or two authors. You must be writing an article or a book, you know, Professor X, Professor Y, or Professor Z. They are the three people are writing. One may be very senior, 60-year-old. Second author may be in the middle ages, 40s or 50s. Third one is very young, in between, in the late 20s, let us say. In this hypothetical work, joint authorship work, it is a collaborative work. That's what the section 2 Y of the Copyright Act definition says. Work of joint authorship means two or more persons coming together and collaboratingly creating a work. What is the work? The definition of work written in 2Z. Work can be a literary work, artistic work, musical work, dramatic work, or sound recording, or cinematograph film. These are the works defined under the definition of work. Then, uh, who will get more rights? Because the professor who is 60-year-old, very senior professor, he will get more rights than the assistant professor in the middle ages or a researcher in the late 30s will get less rights. No. Or person who has written uh, more chapters in the book will get more copyright than other people who have collaborated. No. So, what is the percentage of content written by the collaborative authors is immaterial in a collaborative work or a work of joint authorship. Everyone get an equal right. So one person he can't go and transfer the rights for the publication. Even the writing a publication contract or a translation contract, or if a film producer comes, okay, I want to adapt into the film or a web series. All these things, three people have equal rights. All three have to agree. All three have to sign the contract. All three have to agree to the compensation of the royalties to be received from the person who is going to exploit for the other commercial purposes. So that is the beauty. So what happened recently? The issue of AI authorship came when Stephen Toller, who created an artificial intelligence machine with the machine learning and generative adversarial networks. It is the most deep learning and neural network algorithms. This machine called doubles, when it fed with some photograph of the famous painting of the Spanish painter called Rembrandt, of the 16th century realistic painter Rembrandt. It created a new piece. As if Rembrandt is alive now, he painted a portrait of Professor Kalpesh Gupta. Or Kalpesh Gupta belonged to that 16th century, how Rembrandt would have painted it. Exactly. So, what this artificial intelligence does, when you feed these photographs of one particular work, that Rembrandt's 100 painting was given, and one portrait photo of Kalpesh is given to that machine. First, it learns how the uh, drawing done by Rembrandt, then what kind of colors it has used, color combinations it has used, how brush strokes, because every painter does his color combination painting brush strokes in a different manner. So everything it learns, that is called AI learning. Then it trains and then creates a data sets out of that, various data sets. Tokenization it does, it breaks into tokens each activity and data sets included, and that output comes out, uh, and applying that technology to the portrait of Kalpesh. Then finally Kalpesh portrait came as if Rembrandt of 16th century Spanish painter sitting in front of him and painting his portrait. So this was submitted for copyright protection in the US Copyright Office before my friend Sheila Perlmutter. Uh, Sheila Perlmutter and myself associates in various WIPO treaties. She is a very intelligent copyright lawyer. and now she is posted as a registrar of copyrights. So Thaler application was rejected by her on the concept that intellectual property rights are basically these are uh, provided to the human creations, not for the non-human creations. And that is the one concept of IP. Whether it is a patent, copyright, anything is given to human creation. The creation of idea which originated in the mind. So it may be autonomously creating. It can't be matched with the human, and it can't be matched with the human brain. So people are saying that the strong AI, just like Elon Musk said, the artificial general intelligence, the high AI, or the strong AI, which is going to beat the human brain. So it is unethical to have a authorship of Kalpesh Gupta's portrait created by the Dabus painting, using after getting trained from the Rembrandt's painting, of the learning from Rembrandt painting, the techniques. No, if, the copyright system, the IP system says no, the machine is not human. Number two, the entire IP theory is based on the incentive theory. So the whether it is a patent which has set a term of 20 years, or 20 years the inventor exploits that innovation and technology, makes money. Similarly, copyright, there is a post-mortem auctoris principle associated with the term of copyright or duration of copyright. What is that? Life of the author. So author can enjoy royalties, economic benefits from the work he has created, any work, not only during his lifetime. Let us say that author passed away today. Today is the 8th June. Okay. But if author is passed away today, the term, additional term of 50 years plus life, which a Berne Convention and TRIPS agreement says. But also these countries can give more than that. We are given 10 years extra. Life of the author plus 60 years. When does the 60 years start counting start? Not from today when author has died. That is from the 1st January of the next calendar year. So where is the life for the machine? When there is no life, what? How do you apply the post-mortem actors? Forget about the incentive giving it to that. So why this post-mortem actors principle came? First time it was introduced in 1832. Why? So because author might die without seeing his book becoming a famous, best sold book, best sold painting. He dies. And because author has died, his work enters public domain at that time. His family is suffering in a poverty, can't exploit. Everyone is exploiting in the world. That is book. So the post mortem actors principle introduced at least 25 years. The family should exploit till the boy. Let us imagine the example was given. Author dies when his son was just, or a daughter was just born. So that kid grows up to 25, starts earning. Till then, with some support, financial support has to be given to the family. That was the concept. When it was introduced in 1832 in a new Copyright Act of the British Copyright Act, all the members of Parliament, the UK Parliament, supported it. But one person opposed. Who was the member of Parliament? That member of Parliament introduced English education in India. Do you remember his name? His name is Lord Macaulay, who introduced English education in India. He opposed on two grounds. One is that why you are stamping and impeding the innovation, because works enter public domain, there is no copyright in that. The young minds can innovate on that. Moreover, why you are stopping the access to knowledge? The people who can't afford, they will wait. the weighting will increase. So accessibility, the freely accessible work to the society is important, he said. But his argument was not accepted, and it's still we follow the that postmortem actoris principle. So how it can be applied to AI? On that reasons, it was rejected. But problem, what happened? One application was filed in Indian Copyright Office recently. One Ankit Saini advocate filed a AI generative AI called Raghav AI. The generative AI name is Raghav AI because it was the Raghav Agarwal, a computer data scientist, software expert, created this generative AI. So what they have done, they took a photograph of the sunset in Goa. With that photograph, the Vincent van Gogh, famous Dutch expressionist painter, his famous painting of the 18th century painting. It is called Starry Night. You can Google Van Gogh Starry Night. You can see the photograph of that painting. So they both are put to introduce to the Raghav AI, that is generative AI algorithm. So it created a new work. It's very beautiful. They said, give me copyright for this. Then the copyright office said, okay, it's been autonomously created. What to do? They did not apply their mind. They simply jumped and read the joint authorship definition in 2Z, work of joint authorship. On that basis, they granted copyright to that. Now, who is the human in there? Only Raghav Agarwal, lawyer Ankit Saini, who introduced this, is the author. Who is the co-author? The machine. But machine is not a person. No, the definition says two or more persons. Where is the other person? Machine is not a person. Machine is not person means person has to be natural person or a legalistic person or a juristic person. So it is not a legalistic or a juristic person. The university which you are part and parcel, your law university is a legalistic person or a juristic person because that institution has so many persons, and you are the one as an employee. You create a work. You may creating a project. You may be writing an annual report. And Kalpesh, kindly let me know when we reach the 8 o'clock so that I can
Sure,
talk
sure,
more.
sure. Sure, sure. We have more 10 minutes, sir. So then we'll take up
Definitely.
questions, sir. Over to you, sir.
The problem here is uh, the it is neither a natural person or a legalistic person, because employee who is creating this, why you won't get a copyright because you are already salaried persons. As a task, you are creating a project, university project, or a task you're writing a annual report, any other report. Even though Section 17 says that the first owner of the copyright is the author, but how the juristic or legalistic person institution becoming the owner, because it pays its monthly salary to you, and the work has been done as per the annual action plan, the main vision or mission of the your institution. So by way of that, it becomes the owner. So that cannot be given. That was wrong. Later, it was withdrawn. Similarly, copyright expression has to be original expression. So, do you think that AI creating it is originality is there? What is the originality in the copyright? That is the test. How you test the originality test. In old times, there is a concept of sweat of brow, the labor theory. When you write an article or when you write a book, you work hard. So just like a labor. So you were, because you were working hard. There is a theory of labor, hard work, sweat of brow. So copy, there is a originality is there. Okay, that is the proof of creating the original. You got the originality, you got the copyright. But later the system changed. Um, uh, Skill and judgment concept was introduced by the courts. But when the things moved on, new concepts came of the test for the originality. First, it started with the fierce publications versus ruler telephone. It is a case in American Supreme Court decision. In this, whether Yellow Pages consists of copyright. Yellow Pages is a book contains addresses and telephone numbers of various businesses, organizations. It has been compiled and put. For example, you want to order food. Then you go to the food chapter, the various restaurants names are there. You want to order for some medicine, various medicines. You want to book a car, various car hiring services are there. There are just telephone number like that. So the Yellow Pages book, whether it consists copyright or whether there is originality was there or not. In a fierce publication, a ruler telephone, Supreme Court of America said that there is no copyright in the Yellow Pages. It's just a cut and paste creation. Because don't say there is no originality in that, because you have put money and compiled that into a book. You're selling that book, and you can't get copyright because you have done some investment in that unless the originality is there. What is the originality? Simply you are compiled and in a systematic manner. It's not original. What um, the Bern Convention says? Arrangement. Arrangement itself, systematically arranging itself. That is originality. But that won't come because you have put some labor in creating a database, cut and paste database like Yellow Pages. So it's not the labor theory or a sweat of more theory, not even small skill and judgment. It said there should be modicum of creativity. The concept was introduced by American Supreme Court. There should be modicum of creativity in which small minimum degree of creativity should be there. Whereas the similar case was placed before Canadian Supreme Court. In a CCH Canada versus Law Society of Upper Canada, question came again, what is originality? The Canadian Supreme Court has set the higher levels of originality test. They said that originality is equivalent to something like a novelty. So it comes with the skill and judgment and all that. But when the same question was asked before the Supreme Court of India in a DB Modak versus Eastern Book Publishing Company, Supreme Court said it accepted the fierce publication concept of modicum of creativity with a minimum degree of creativity, skill, and judgment. That is the originality. So, where is the originality in that? Recently, Petronius AI, a company surveyed when you are using OpenAI AI's ChatGPT and when you are using Gemini, Google's Gemini or Microsoft Bing or any other Copilot, any other large language model based, algorithm based, this thing, artificial intelligence. When you give a prompt, either by text, you type it, or by voice prompt, you say, please write a 1,000-word article on originality in the copyright. This is the question you put the prompt. It's beautifully it comes out with the article, with the introduction, what is originality, and whatever I have told, maybe it must be producing. So finally, can you publish that in any journal? So it will be treated as a plagiarism. Professor Kalpesh will reject, simply throw that your ChatGPT article in a dustbin. He says, yeah, your Turnitin is saying the 100% similarity. So Where is the reference? Where is the citation? Nothing is there. Then you know that your university authorities or your supervisor will not accept this, or your publisher journal will not accept this. You put one more prompt to that. My dear chat GPT, the article, 1,000 word article you have written very well, but return this article again to me with citation or referencing. I challenge you, it will not give more than two couple of citations. It must have collected data, humongous data available over cloud or internet. It must have got from the various newspapers information, the Google books which have been scanned, articles which are freely available over internet, every or various other databases. So uh, it is not original. 80% is cut and paste work. That's what the Petronas IA said. So originality, forget about originality. Whenever you create a work, you get an exception. So what these people, when a case is filed against them for not taking the author's consent or right owner's consent, for training the and learning it and creating a content. If you see the contract of the OpenAI's ChatGPT, it says it is your headache. Giving a prompt is your headache. When it churns out and text data mines the data and give it to you output, that is your headache. If you are using that illegally, publishing it, and some right owner files a case against you, that is your headache. You can't file a case against OpenAI. But the cases, everything is filed against OpenAI or Google or Microsoft because you can't run away from your responsibility and accountability. How on earth you access to the book? Because you can't when OpenAI and all these companies, AI companies started selling, oh, we have copyright exceptions in that. It is a transformative work as per the fair use of American concept. But no, it's not a transformative work. Transformative is work is the article written by you. Reading 50 books and 100 articles, you must have written its own language, but when you use as a quotation, wherever you're doing paraphrasing or quotation, using a quotation, you cite and referencing is that. Then it is not a plagiarism. It is a original. It's a transformative work. So it cannot be transformative work. It can't even a derivative work when it is infringing the copyright. Without accessing, when you access the machines, AI machine access, there is no consent, permission to access. That's what the New York Times case has filed. Getty Images has filed. Whereas databases have filed cases against them. Because what Ben Convention says, the Article 10, using the quotation, it says lawfully access work only, you will take out the quotation and use. What is the lawfully access work? When you subscribe a journal, which allows you to access it after login ID and password. Or you walk into a library where university library legally purchased the copy, physical copy, and kept there. That is lawful access. Or you yourself go to the market or buy that book, or online you order the book. Online book ordered, maybe a physical book delivered at your door, or you have been allowed to download a PDF version or a Kindle version and all that. All these are whether digital or physical or legally accessed because you have purchased or someone has purchased, you have borrowed it. Like you borrow a book from library or a friend, etc. On that you write an article. Okay, the accessing. Where is the purchase happening here? No, everything your algorithm is going, reading, learning, training, and coming out, creating a tokenization and data sets, and then finally the learning model is created, is churning out the output, and and that output is you're taken a print out. So neither you're taken permission nor paying any royalties. It's illegal. So this is
Hello,
the
sir.
big issue being discussed in the U.S. Supreme Court. Hopefully, some decision will come. But recently, we are answered a Parliament question in the Rajya Sabha, which was drafted by me in the ministry. Better, it has been released in the press release also. It clearly said the present laws completely address these issues. But what we need to introduce is text data mending exceptions for education and research, because you guys who are doing research are teaching educational using the educational process, doing the text data mining using this kind of artificial intelligence algorithm should not be harassed either by the authors or the right owners. So I'll end my talk here. Jai Hind. Now I'm open for the questions.
Yes, sir. So we have few questions here. The first one is, sir, there's a question that what kind of conditions has to be printed on the book to protect original author, and how long author has to wait for copyright registration practically?
So I already told you that copyright is automatic. The moment you write a book or article, copyright is there. So registration copyright is only, voluntary registration is not a mandatory. You're not getting copyright after registration only. You already got it. The moment the book is published, you got a copyright. Even though book is not published, let us say you have a script with you, it has not been given to the publisher. Even that also copyright in that. That can also be registered. So with registration, you're not getting copyright. It is only giving a certificate of evidence. Already the work created by you has a copyright. Yeah. Next question.
Yes, sir. The next question is, uh, so is the subject matter of personality rights of celebrities, as observed in recent cases, covered under the copyright regime in India? If not, what steps can be taken for protecting the same under Copyright Act?
Yeah. Copyright Act does not expressly mention about personality rights, but there are implied things are there, especially the dialogues which have been used by them, reproduced without permission, and there is a copyright exists in the kind of dress they are wearing, that particular character. Recently, a personality right case was decided in favor of Jackie Shroff. Jackie Shroff, the way he wears a Bengali dhoti and a jacket and alcohol, whiskey glass he is holding, the way he blotting out dialogues like we do, that everything, the way it is done, that is a cinematograph right is there. So you can't recreate it unless you get a permission from him. Forget about, because the every dress is a fashion design. There is a copyright. There is a design right, and then the brand name is it can be protected as a trademark. So that extent is protected under the copyright law. So there are only few countries have expressly mentioned about the personality rights, but courts are protected with the personality right with a combination of trademark, design, and copyright. Yeah. Next, please.
So the next question is that what kind of copyright has to be claimed for creating content in YouTube? Any specific challenges the YouTuber may face in case of violation of copyright?
You mentioned YouTube.
Yes, sir. The kind of challenges that the YouTuber may face in case of violation of copyright, for creating content in YouTube.
No, no. In a content, for instance, it is a user generated content. When it is uploaded, because you have generated content, beautiful video you have made. You made some comments on that, and without realizing it, you have uploaded on Facebook or Twitter. It has become viral. Some guy takes it, uploads it on the YouTube, and he uploads it with a consent, without consent with you, but without the knowledge of uh, YouTube, he will agree to these both subscription model and advertisement. When the very creator, you go and watch that, ads are coming. That fellow is the ad revenue is making, both YouTube is making and sharing with the person who has uploaded. To remove that, there is a self-regulation policy with the YouTube. The moment they know that you are the author, they send because somehow it the or their algorithm is mentioning that it's created by you. They sent a notice to you saying that your content has been uploaded. Do you want this to be deleted? Do you want this to be continued with the advertisement revenue sharing formula? Then whichever you can agree, or you want to delete it because you don't want everyone starts uploading this, then it has to be deleted. And because you are as a content owner, you said delete, they have to take down. But sometimes even YouTube doesn't know who is the owner. Then when you discover, you send a notice to them. Then the YouTube says, what is the proof that you are the owner? Somebody has uploaded it already. Is earning money. Then you give an evidence that, oh, no, it is been created by you. You are the owner and the author of this content. Then they will send a notice to the person who has uploaded. That guy is not replying. So some time needed for that process. We have given 21 days time. This is a safe harbor because otherwise YouTube has to pay the compensation to you. So YouTube, not knowingly has done that, unknowingly has done that. So a kind of safe harbor which American Digital Millennium Copyright Act introduced in 1998. Same concept we introduced in our Copyright Amendment 2012 in the section 52(1)(c), where a court order has to be released saying to take down. Then finally, YouTube also said, I'm not satisfactory because the person who's uploaded saying that it is his consent. Then you have to run and convince the court and get a takedown order from the court. Then, if YouTube doesn't remove it, then vicarious infringement will be applied, and then okay, you are making money illegally on allowing the infringing content stream from your platform. So YouTube is liable once the court order comes if they take down. Don't take down. But during the period of 21 days, it's okay. But many people say 21 days is too long. By 21 days, that video become very old. Oh, जो पैसा बनाना है बना लिया उन्होंने. The infringer was unauthorizedly uploaded. So many content owners are not happy with that. But that goes on like this. Yeah. Next question.
So, somebody's asking regarding performance rights. Does each IPL player have such rights and use clips of his performance in the match for sharing with his friends or in social media?
Yeah. This question came before Delhi High Court in NDTV case and also Star TV versus Piyush Agarwal. Whether the clips, small video clips of IPL matches, before that, the ICC case was there. Now it can say it can that is this judgment is applied to IPL. Small clips you keep sharing and in your WhatsApp or your social media status or any social media websites. Is that legal? The court said once this has been done, uh, anyone can share because there is no copyright in that. Only the entire small sharing of small clips, you're not infringing because it is already in the public domain. But entire video, which is uploaded only in, let's say that ESPN Star Sports or the broadcaster who has the right, and when the linear broadcasting happening, only he has the rights. So cricketer, uh, question of performance of the cricketer as a performer is not recognized. Of course, many people interpret the definition of performance. The list has been given there, who is the performers. Then any other performance it's given. Many people argue that the cricket player, the sportsman is also a performer. That has not concretely described either in the act or in the um, any court case. Coming to about the score, whether the score itself, so much runs have been scored, so many wickets have been fallen. Court also said that this is also in the public domain. If a news channel showing this in a small scroll, this is the match status. It's not infringing the copyright of the IPL or BCCI or International Cricket Committee, etc., ICC. And even somebody, some news channel is getting this score is sponsored. Let us say that Airtel score, Vodafone score, Geo score, like this. Even that such as commercialization need not be taken permission and royalties to be given because everybody knows. You suddenly ask your friend, अरे अरे भाई क्या 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 स्टेटस है आईपीएल मैच का? अरे यार, कोहली तो अभी आउट हो गया, धोनी आउट हो गया, 8 विकेट गिर गई, एंड ओनली 1 ओवर इज लेफ्ट, 50 runs to be made. ये जीतेगा नहीं. This is the talk goes on. So it is already in the public domain. Where is the copyright in this? So that's what the Delhi High Court said. Yeah. Next question, please.
So we'll be taking the last question. That is, how can the issue of derivative originality be addressed in AI chat models like ChatGPT, which generate outputs based on data that originally belongs to others, resulting in content that is not entirely original but related to the input data used for machine learning?
Oh, this already I explained in my talk that there is no originality in that. And derivative work comes with originality. What is the derivative curve? For example, you take the any book like 3 Points Someone, the book written by Chetan Bhagat. It was adopted. A derivative work was created as a Three Idiots film. Okay, so there is a originality in that creation. That extent is allowed. But when there is no originality in adapted or adaptation or a derivative work, so lack of originality, there is no copyright in that. If there is no originality, it's simply copied and pasted, and a kind of collage kind of work has been created. So there is no originality. That is the main argument um, in the courts by the Authors Association and Right Content Owners Association. Let us see how courts are going to react to this. But I personally feel that um, derivative work has to be original to get any copyright. For example, the various songs are being created. So the with the algorithm generative AI mimicking the voice of singers. So it is a you can't say it is a derivative work. It is a violation of a personality right and also the performer right. without consent you can't do. But recently, A.R. Rahman created this kind of AI generated work from the famous artists who have passed away. But he has taken permission from the uh, next generation right owners who are living, uh, the legal heirs of that famous personality, and created this content and apparently has paid some percent of royalties to them. This is the gentleman way of working in the AI network algorithms and creating derivative ones. Yeah, thank you, Jay. Thank you, Dr. Kalpesh.
Yeah, thank you very much, sir, for your excellent session. I can see there are so many questions are there. If we take it, will go beyond 9. So, obviously, people have raised hands. Sorry, we won't be able to take more questions. I can see like a lot of things are there. Like there's no registration part, that is fine, but a lot of challenges are being. We can see for last, I would say, a decade, and you rightly pointed out and share your experience, like what are the things are happening at a particular point of time. Obviously, this changing the technological part and the copyright issues. And then I hope participants they benefited from the insightful session and then point of view of Raghavendra sir. And then I hope it will be helpful in your teaching or practical your professional career. Sir, on behalf of organizing committee, we are thankful to you and then look forward to see you in future events. Sir. Thank you very much, sir.
Yeah.
Jai Hind, sir. Thank you. Thank you very much, Priyanka, for moderating today's session and all the
Thank you, sir.
participants for
Thank you, sir, for
joining.
the question.
Yeah, thank you very
Yes, sir.
much.
Thank you, sir.
Thank you very much.